So if we think then, what are the solutions to the skill shortages? And more importantly, for my purposes as an immigration lawyer, does the solution or does part of the solution lie in immigration into the UK? And I think the answer to this has to be, well, yes, in part, immigration is inevitably going to play a part in forming the solution. And as we've already said, the government has resorted to immigration as part of the solution as well. If we're thinking about immigration into the UK, then to plug skills shortages in the UK market, the most common route into the UK for migrant workers is under what's known as the points-based immigration system and via sponsorship. Now, before an organisation in the UK can sponsor a worker to come and work here, they need a sponsor licence, which is effectively a permit issued by the Home Office, which enables them to bring workers in from abroad. We don't have time in the short space of time we have here to go into the details of what the eligibility criteria are for a sponsor licence and what the application process looks like. That would really warrant a session in itself. But suffice it to say, before the Home Office is going to grant any organisation a sponsor licence, it's going to need to be satisfied that the organisation is honest, dependable, genuine and reliable. And the Home Office is also going to want to see supporting documentation to prove that the organisation is a legitimate organisation and that it has a genuine operating or trading presence here in the UK. And once that sponsor licence is in hand, there are two main routes under which individuals can be sponsored to come and work in the UK. Both of them have different eligibility criteria, and again, we don't have time to go into the details of everything today. But the two main routes people will be familiar with are the skilled worker route and the intra-company transfer route. For both of those routes, there are minimum skills thresholds which apply, and this is why post-Brexit, recruitment, certainly of European nationals, is becoming more challenging, because previously it didn't matter what skill level the role European nationals were coming here to do, they were eligible to come and do them, whereas now it has to be a role that's sufficiently skilled. And for the skilled worker route, the skill level is A level and above, so the role has to be classed at being at A level and above in order to be sufficiently skilled. For intra-company transfer, that's degree level or above. And interestingly, earlier this year, the government actually reduced the skill level for skilled worker. It was previously degree level and above for both intra-company transfer and skilled worker. And the effect of that is that across various different sectors, there are now roles which are capable of sponsorship, are suitable for sponsorship, which previously weren't deemed to be skilled enough to be sponsored. And so just to go through a few examples, in the construction industry, builders, carpenters, welders, plumbers and electricians are now capable of being sponsored. In retail and leisure, sales supervisors, sales administrators, warehouse and logistic managers could all now be sponsored. In the food and drink industry, jobs such as chefs, bakers, butchers, bar and restaurant managers can all now potentially be sponsored, providing that the various other eligibility criteria are met. So I think that's definitely an option for lots of organisations, is to go down the sponsor route. The other point to be aware of with sponsorship is that there are minimum salary thresholds. So again, for skilled worker, there's generally a minimum salary threshold of £25,600. In some circumstances, the threshold can be lower. In some circumstances, it can be higher. But again, what this is doing is precluding those lower paid roles from coming into the UK. Just a couple of other points on sponsorship, which I think are worth mentioning. One is administratively, it's quite a burdensome route to go down, and it's always worth getting advice on the application itself, but also on then sponsoring any individual under the sponsor licence. The other point that has to be made when it comes to sponsorship is it's not a cheap option. So we have visa fees for the individual coming into the UK, which are around £1,200 for a 5-year visa. On top of that, for each year of sponsorship, there's an immigration skills charge, which is £1,000 per year. For each individual coming in, they have to then pay £624 per year of sponsorship towards the NHS. So the fees tot up effectively. It's not a cheap option. In terms of circumstances where sponsorship isn't an option or isn't appropriate, there are various other routes which is really important, I think, for UK businesses to be aware of. One of those is the business visitor route. So individuals who are coming into the UK to do certain prescribed permitted activities which are linked to their overseas employment may be allowed in for up to six months under the business visitor route. And when we're talking about permitted activities, there is a prescribed list of activities that are permitted under this route. So things like attending meetings, undertaking site visits, coming to negotiate or sign contracts are all permitted. Other intracorporate activities are also permitted under this route. So where there are companies in the same corporate group, an overseas company might send an employee to the UK to work on a specific internal short-term project or to share skills and knowledge with employees in the UK. So that's a really important route to be aware of. There's another route which I'm seeing clients are increasingly relying on under the business visitor route, which is an activity which relates to foreign manufacturers or suppliers, where a UK company purchases or leases equipment or computer software or computer hardware under a contract from a foreign supplier or a foreign manufacturer. That foreign supplier or manufacturer can send its employees to the UK to install or repair or dismantle or service that equipment. And that's really helpful in circumstances where UK businesses are bringing equipment in from overseas. And due to a relaxation of the rules around that particular exemption from the 6th of October of this year, that now also extends to third parties who are part of the contractual arrangement to provide after-sale services. So if a third party is going to be providing services under a warranty, for example, that third party may also now be able to rely on this route to send employees to the UK. So I think all of those routes are really important. There are various other routes into the UK in terms of immigration options. I don't have time to go through them all now, but one thing which is worth mentioning, I think, is a frontier worker permit route. So this applies to individuals who are primarily resident outside the UK in the EU, but who come to the UK on an occasional basis to do work here. And provided that they had been coming to the UK to do occasional work before the end of the Brexit transition period at the end of last year, they might be able to continue doing so, provided they make an application for a frontier worker permit. And the key thing there is that's a much easier route to go down and a much less expensive and administratively less burdensome route to go down than sponsorship if the circumstances are appropriate and permit it.